Hi, this is Lloyd Princeton with Design Management Company. Happy to be here today as the world seems to be getting back in motion with work. And I had been prompted by a few people to hold another teleconference, and when I asked them, what would you like me to talk about, I got radio silence. So then I decided I would talk about a timely issue with what's going on right now socially, and that is of qualified immunity. Before we dive into it, I think an entirely appropriate quote. One of the great liabilities of history is that all too many people fail to remain awake through great periods of social change. Every society has its protectors of status quo and its fraternities of the indifferent, who are notorious for sleeping through revolutions. Today, our very survival depends on our ability to stay awake, to adjust to new ideas, to remain vigilant, and to face the challenge of change. That's by none other than Martin Luther King. So, indeed, we are in a time of change, and as horrific as the events have been, I think that there is indeed a silver lining to the cloud, and we're gonna get to that in a few moments. Real quick, from a business perspective, seeing as I am in the design industry and on the recruiting side, I will say that I have not seen an increase in availability of design professionals on the residential side, which my interpretation is that the residential design market is still strong. I knew it was strong leading into and through the lockdown, and I knew that there were a lot of projects, and I am interpreting this to mean that things are still strong. I am seeing a bit of uptick with resumes and such from the hospitality industry, and I suppose that is to be expected, because I know that the travel segment has been hit hard. But that is the limited view and perspective that I have at the moment, just purely gauging who's been reaching out to me. So that's it from my 2 cents on business. But taking advantage of a period of social change, I thought it would be appropriate to invite the Institute for Justice to present to us today. I've been following the Institute, unfortunately, only just a little over a year. I wish I would have been paying attention to them for many years, because they are assiduously fighting for our rights, and they are taking things right to the Supreme Court. It's like when you watch movies, they're going to say, I'm going to fight this to the Supreme Court. Well, these are the people that are actually doing it. And before I introduce our guest, the IJ had 2 victories just yesterday. And just to give you perspective on the type of stuff that they're dealing with, in California, a gentleman by the name of Bob Smith has spent 3 decades teaching farriers, something I'd never heard of, but it's on horseshoeing. And if you're in the equestrian world, you'll know that being able to shoe your horse and do that is germane, and to their well-being, and for some people it's their livelihood. Back in 2017, the good old state of California said, "Gee, you can't have any students who don't have at least a high school diploma." Kind of crazy. So meaning that a ranch hand who could benefit from a job and the ranch owner benefits from having somebody who can do it, but if the ranch hand didn't have a high school diploma, wouldn't be able to get this education. And the IJ took us to court and won. In South Carolina, even almost as crazy, or maybe even crazier, a woman by the name of Kim Billups wanted to become a tour guide in the city of Charleston. Beautiful city, and if anybody's ever taken tours before, there's always they're a mixed bag of tricks, but we look for things that are entertaining and enlightening and kind of fun, because you're there for an hour or two and you want to have a good time. And yet the city decided to institute arbitrary licensing that said that the city had the right to approve a script in advance, and they could decide which stories could be told and not told. And if you did this without your license, you could be fined and also go to jail. How about that? So they won in a federal appellate court as well. These are kind of small examples, but there are far things that are much more important. And now it is my pleasure to introduce Patrick Giacomo, who is working with the Institute of Justice as the attorney representing qualified immunity. And I'm going to ask Patrick to take over and jump in and give us tell us what qualified immunity is and how you think things are going to start turning in light of what's happened with George Floyd. So, Mr. Giacomo. Make sure you're unmuted. Maybe that might help too.
There we go.
It's
all right.
Over to you.
I was checking my mute. I thought I was crazy. Thanks for having me on, Lloyd. I'm always happy to discuss qualified immunity. It's obviously a very timely issue, but it's something that I've been working on for quite a while now. And notwithstanding its sort of boring-sounding name, qualified immunity is actually centrally important for all sorts of civil rights and constitutional litigation. And qualified immunity was created in 1982 by the U.S. Supreme Court as a matter of judicial policy making. So it wasn't based on the Constitution or any sort of statutory language. The court just said in 1982, we think it's really difficult for government officials to have to deal with getting sued when they violate people's constitutional rights. And so we want to make that harder to do. And so what they did was they enacted a sweeping default immunity that applies to all government officials, local, state, and federal, for any claims brought against them for violation of the Constitution or civil rights. And so, in effect, what happens is if, for instance, a police officer violates your constitutional rights under the Fourth Amendment to be free from unreasonable searches and seizures, and you sue that police officer, the police officer has qualified immunity, and then you as the victim have the burden to establish to a court that your rights were clearly established. And that standard really is where a lot of the havoc comes into this process, because under the Supreme Court's rules of qualified immunity, to clearly establish a law or a right, you have to point to an earlier court case from the U.S. Supreme Court or the Court of Appeal in your federal circuit that said what happened to you under the same particular facts and circumstances was already held to be unconstitutional. And if there isn't such a case, that officer is entitled to qualified immunity. And I'll pause here quickly to say, before 1982, there was another doctrine that was also called qualified immunity that you'll see splashed around in the newspapers a lot. And it was an entirely different thing. So in 1967, the U.S. Supreme Court said, we're going to create something, we're going to call it qualified immunity, but all it really was a defense of good faith that a government official could raise and say, yes, I violated your constitutional rights, but I had a good faith basis for doing it. I might have been following an unconstitutional law, or I was otherwise acting reasonably. In 1982, when the Supreme Court created qualified immunity as it is today, they threw out that entire standard. And so now it doesn't matter whether you have good faith. Your subjective intent as an officer of the government is entirely irrelevant. And so that means that with qualified immunity today, even the bad faith and intentionally wrong actions of government officials are entitled to this special protection. And so to give you a couple examples, there was a recent decision from the Ninth Circuit Court of Appeals, which is in California, involving a situation where a number of police officers in Fresno, California, stole more than $200,000 while executing a search warrant. And the men from whom they stole the money sued and said it was a violation of the Fourth Amendment. That was an unreasonable seizure for you to steal my money. And the case went up to the Ninth Circuit, and the Ninth Circuit said, well, even though every society in the world knows that stealing is wrong, because there wasn't a specific case in the Ninth Circuit that said stealing money while executing a search warrant constitutes a violation of the Fourth Amendment, there was no clearly established law here, and therefore the officers who stole the money are entitled to qualified immunity and cannot be sued. And so there's another case that shows not only our intentional actions, but reckless and grossly negligent actions are also protected. So there was an officer in the 11th Circuit who fired his gun into a group of children trying to shoot a non-threatening family dog. But instead of shooting the dog, he shot a 10-year-old in the leg. And the 11th Circuit likewise said, well, this is obviously not good behavior. But there's no case in the 11th Circuit that says recklessly shooting your gun into a group of children is a constitutional violation, so this officer is entitled to qualified immunity. So that gives you a good backdrop substantively of what qualified immunity does and why it's bad. But there are several other things that we should highlight, because a lot of it, especially in the context now after the George Floyd killing, is getting focused exclusively on police. And in reality, the thing to keep in mind is that qualified immunity applies to all government officials, not just police, not prison guards, mayors, governors, regulators, people who work for federal agencies, anybody who works for the government and is enforcing laws. And if they violate your constitutional rights, they're entitled to the same type of qualified immunity. And one of the other problems with the clearly established test is that because it focuses on the particularities of the circumstances, the more outrageous your behavior, the more likely it is that you'll get away with it. And finally, about 15 years ago, the Supreme Court announced that when doing this analysis of qualified immunity, you don't have to first decide whether there was a constitutional violation. Instead, you can dispose of the case by just deciding whether there is clearly established law on the subject. And so what that means is a lot of the time, courts will take a case and they will say, we're not going to decide whether the official in this context actually violated the Constitution. Instead, we're just going to point out that there's no clearly established law, meaning there's no other court case like this, and grant qualified immunity. And that's exactly what happened in that California case with the stealing police and in the 11th Circuit case where the cop shot the kid. Both times the court said, we're not going to establish a new constitutional right here, which means that those very same police in California could steal money again while executing a search warrant, go to court, and be given qualified immunity. So it really stymies the advancement of constitutional law. It stops people from being able to effectively enforce their constitutional rights. And it basically is a license to lawless conduct for all government officials who are enforcing any type of law against anyone in the United States of America. And so as part of our larger project on immunity and accountability, qualified immunity is one of the main goals we have of getting rid of special protections that allow government officials to violate the Constitution and allowing people to hold government officials. Yes.
And I normally don't interrupt, but I'm going to do it just this time because I something immediately comes to mind, and I don't know if you want to pepper it in now, later, or avoid it altogether. But specifically with George Floyd, how does this resolving qualified immunity, what kind of impact does that have, given what we all know to be the control that comes from the police unions? And the specific example I'm going to use now is, even in George Floyd's case, the Minneapolis, police officers, the union or association, is fighting the fact that those 4 officers were terminated from their positions, terminated and or late, if they weren't, each one of them wasn't fired. I don't know the specifics. That you have unions that are very powerful. So does one overlap the other, completely independent, and where does this leave us? And so I want to add that to the mix.
So specifically in the context of police accountability, qualified immunity is one of several independent issues that are probably going to need to be looked at for the sake of restoring some level of accountability. Qualified immunity applies to civil rights and constitutional lawsuits. So it doesn't apply to criminal lawsuits, and it doesn't really have any impact on whether or how police can be fired. And so as you noted, there are plenty of problems that are caused by collective bargaining agreements entered into by police unions that make it very difficult to fire police regardless of the number of complaints that have been made against them or bad actions that they've taken. So you've got several different buckets that pertain to police in particular, and qualified immunity is just one of those buckets.
Okay, thank you.
Yep. So other than that, like I said, qualified immunity is getting lost in the news, applies to not just police, but every type of government official. So, for instance, one of the cases that's before the Supreme Court right now involves members of the Texas Medical Board who went into a medical office's confidential files and rifled through them without a warrant. And the Fifth Circuit granted qualified immunity for those medical board members. And so you've kind of seen this critical mass coming together in the Supreme Court since October. It's been collecting cases long before what happened in Minneapolis. And now it's just all sort of coinciding together. The Supreme Court still has 7 cases involving the application of qualified immunity that it's supposed to decide. It could decide as early as Monday whether it's going to take some of those cases. But now, because of qualified immunity getting such a large role in the news, obviously you've got the different proposals being made in Congress to eliminate qualified immunity, and a lot more people are talking about this doctrine that was otherwise fairly obscure until recently.
So then what in addition to what the work obviously that you're doing, what can we do as lay people to further this? Because, I mean, the idea that you can't sue government in general, and listen, one of the funnier things I ever saw was a listing that said, like specific numbers, and I don't remember, but it was like, this many people pulled over for DUI, this many people, a bunch of people filed bankruptcy, and all of these things that you were going, oh my God, this is terrible, and it was like, yeah, these are the members of Congress. So it's like it's like a license to sell and a license to print money. So give me the top 1, 2, 3 things that we can do as lay people to, support your efforts, but also just to fight this in general.
So I think as far as fighting qualified immunity, the most important thing that lay people can do right now is to just understand the basic contours of how qualified immunity works and be ready and willing to discuss those with other people and explain, for instance, things like qualified immunity is not something that just applies to police. Qualified immunity is not something that you can find in the Constitution or any statute. And qualified immunity is just a court-created doctrine that applies to all government officials. Unfortunately, the solution for qualified immunity probably lies with the Supreme Court or Congress because of how sweeping it is of a doctrine that the court created to apply to every single person who's enforcing the law. So it's really difficult to think of a local level patch to solve this problem. Another thing I'll point out, though, is that many states have something like qualified immunity, if not calling it qualified immunity. That's something that I think lay people would probably have an easier time addressing with their state representatives. There are potential solutions that could lie in talking to your local government and asking them to waive the special protections they have and take responsibility for the unconstitutional acts of their employees. But one of the real puzzles of qualified immunity is how we can solve it without getting the Supreme Court to change its mind or Congress to act in some sweeping manner. And right now, we don't really have a great answer other than being hopeful that the Supreme Court will do something, and if they don't, that Congress might step in.
Well, and I think one of the things, once again, the silver lining to the George Floyd death is that all across the country, many municipalities, more, I guess more at a local level, and sometimes at state levels, aside from the fact that they're wanting to rein in, certain law enforcement protocols, there's other ones. I mean, when you talk about the idea of defunding departments, I think what it's going to do is it's going to give certain mayors and people like that their green light to go ahead and fight, the stranglehold that the unions have on them and have had on them for a very long time, and really just to kind of bring some equilibrium to their contracts and to the future negotiations, and that, minimally they're going to say, well, actually, no, it's not okay to have, an officer who has been written up countless times, still on the force, and these, and whatever you consider disciplinary, we don't. We actually need to see something like this because we're not willing to tolerate, anymore. So maybe, and as I said, even if that's the case and it just affects one area of law enforcement, the more cities that start doing it, knock wood, that will empower others to do the same thing. So
yeah, and that's I definitely think that's true. And as far as police reform or police accountability is concerned, there are a lot more things that can be done outside of qualified immunity and things that can be done more on a local level than qualified immunity would require. And I think some of those things include reducing the number of things that municipalities and states have police doing. So right now, there are just so many reasons that police might stop someone to ask them about something or arrest someone for something relatively minor. And because there's just such an enormous volume of things that are illegal and things that police are in charge of enforcing, the law of large numbers suggests that you're just going to have these problems until you stop over-policing everything. And so
that's a very good point.
And so IJ deals with that in several of our other areas where we deal with fines and fees, policing for profit, where you basically have police in your small town acting as a revenue generation source. If you put an end to that, police will be involved in people's lives a lot less, and so the chances of things going wrong will be a lot lower. And same thing with civil asset forfeiture. Because of asset forfeiture, the police have an incentive to be involved in all sorts of stuff that they probably otherwise wouldn't be involved in, because if they're able to find a large amount of money, they can say that there's some reason for them to seize it under civil forfeiture, and now they're encouraged to go out there and have that many more contacts with people that they otherwise wouldn't have.
Absolutely. It's we could go on a lot in there. There's so many nuanced layers of this. This reminds me of the grass cutting story. I feel like it's maybe from a house that was in Florida, where the neighborhood association said grass has to be kept at a certain height. Owner was gone, for taking care of an elderly mother in another state. Grass got too high, and they decided that they were going to go ahead and slap tens of thousands of dollars of fines, and then go ahead and, of course, take the house to pay for them. Those are, egregious things. But once again, you think when things like that start to happen, that's when the law enforcement gets pulled in to enforce said things, and that's where they get to go check out a property and go do all kinds of stuff. So there's far-reaching and interwoven ramifications of all of this. And one of the things that, also, comes to mind, aside from, being able to support an organization like yours that's specifically addressing these matters, I also, have to remind people that they have one thing that they can do that's amazingly powerful and frequently underutilized, and that's their power to vote. So many people are so busy voting for popularity or party lines instead of really looking at candidates who would truly affect change that needs to be changed. So people just vote the same people in and then bitch that things aren't changing. And, until you get enough legislators at all levels who are, who agree that term limits or whatever pick one, unless you get the right people in there, you're just going to keep, you're going to encourage and procreate the same stuff over and over again. So I wish more people had the wherewithal to vote their conscience and vote for the right people that are trying to get into office.
Yeah, and I also think there's another good point in there, which is that people don't realize how much more influence they have on a local level than they ever could imagine having at the federal level. And everyone is so interested in federal politics because it's obviously the flashiest of the bunch. But if people want to get involved at their local level, at their city or their county or even their state, there's just so much more that you can accomplish there, usually as an individual, than you could ever accomplish by, trying to get involved with federal politics.
Yeah, no, absolutely, and I've heard that before, and I'm so glad you brought that up. Well, listen, in the interest of time, as I promised, unless there's another point you'd like to share, I would open this up to questions.
No, I'm happy to answer any questions people might have.
Okay. Are there any questions?
I have a question.
Please.
It's Gary. My question is, if when you talk about qualified immunity, the courts have to look for a precedent before they can decide on a particular situation that has arisen. How is precedent ever set if the courts avoid that task?
Yeah, That's a great question, and that's actually one of the problems that's been pointed out with qualified immunity, which is that people are calling constitutional stagnation, which is because of these standards, there are a lot of courts who will just opt not to answer constitutional questions, and then the universe of potential clearly established rights stays the same for years and years. And so that question itself identifies one of the main problems with the standards we use to apply qualified immunity, because, like I said, in the case with the police who stole the money or the cop who shot the kid, it's still not clearly established in either of those jurisdictions that what happened there was unconstitutional, which means the next officer who does it will be able to get away with it.
So would you be able to, who would then appeal to a higher court to establish a necessary precedent in some of these crazy examples that you have given, where clearly it's unreasonable and unconstitutional?
Right. Well, that in itself is the problem, because, for instance, that case with the stealing police, that was a case where we filed an amicus brief that the U.S. Supreme Court recently decided not to take the case. And so once the U.S. Supreme Court doesn't take the case, that means it's done and nobody else is going to talk about it. And the case with the cop shooting the kid is actually still pending in the U.S. Supreme Court, and maybe we'll find out Monday if they're willing to take that case. But without the Supreme Court stepping in at that point, there is no court who will decide whether that is or is not unconstitutional.
Thank you very much for giving me that answer.
Yeah, well, and Gary, this also, unfortunately, this is a prime example, and Patrick would have a very good legal term for this, but it's a prime example of common sense not being common practice. Even though a lot of people look at these things, go, yes, we're 100% correct. And the one, I don't know if this was an IJ case or what, but there was the young woman whose boyfriend was wanted by the police, and I don't remember the circumstances, but drugs or violence or something. And she was in her apartment, and I guess she came out because the police were there, and they go, "Is your boyfriend there?" And she goes, "No, he's not there." And well, they go, and this is key, "Do you mind if can we go in and look for him?" And she's like, "Sure." Well, they didn't go in. They blew the place to pieces. They shot more rounds of artillery and ammunition in there, destroyed it, literally. I mean, it was destroyed. And she goes, "What the F? I told you could go in." You didn't need to go in. And so she went ahead and sued. And, of course, the courts, and once again, she lost because they said, "You gave us permission to go in." Yeah, like through the front door, opening it, not blowing, And yet, any reasonable human being, I mean, I wish there was just like Patrick, there was a reasonable standard of care where someone could say, yeah, this was not reasonable. This was an excessive use of force, So that is an IJ case. It's called West versus Winfield, and it's one of the cases that's currently pending in the U.S. Supreme Court. And you really touched the right nerve there, because the actual technical legal issue in that case is whether it was clearly established to these police that when a woman says you can enter her home, that doesn't include shooting tear gas canisters through all the windows. And the court said it wasn't clearly established. And so you find these absolutely ridiculous circumstances like this where courts just treat police like they're absolutely unthinking automatons that couldn't possibly apply any amount of judgment. But another thing I'll say, and maybe this should be the last point, is, you said you wish that there was just some application of reasonableness that was applied to police. And that should be the standard, and the reason it should be the standard is because that's the standard that's set forth in the Fourth Amendment, which says that police can't unreasonably search or seize things. And so that's the standard that courts should be applying when they look at the actions of police. They should just say, was it reasonable? And when they do that, it takes into account all of the circumstances. And so a lot of times you'll see people who are apologizing for qualified immunity or police abuse, and they'll say, well, police have a difficult and dangerous job, and a lot of times it involves split-second decision-making, and we don't want to second-guess those decisions. And I agree with that. I think that the Constitution agrees with that, but courts aren't deciding cases based on the reasonableness of an officer under the same circumstances, faced with the same split-second decision-making. Instead, they're applying this bizarre standard of qualified immunity
that just completely takes away any actual reasonableness and throws it to this weird technical analysis of what's in the law books at the time of the actions taken by the police.
So in a sense, really what they're doing is they're violating our Fourth Amendment right day in, day out.
No question. I mean, that is the exclusive and explicit purpose of qualified immunity, is to protect any government official who violates your rights from having to answer to a court about whether or not they actually violated your rights. Instead, they can just say qualified immunity, and the court doesn't have to look at whether what they did violates your rights. Instead, it can just look at these weird standards that qualified immunity has created.
Craziness. Once again, common sense is not always common practice. Well, Patrick, I'll on that note, I want to go on record as saying that I actually thoroughly believe that the majority of police are good and do their jobs and are in it for the right reasons. And unfortunately, what we see and what we get. The good news doesn't get presented. It's the bad news and it's the bad apples. But there's clearly enough bad apples around that are wreaking havoc, and that needs to be addressed. Now, politicians, on the other hand, they've got way too many ulterior motives, and just the way the way that they get into office and the money required to do it, it just unfortunately feeds and fuels, so many special interest groups who, hold them by the collars because they said, we got you in, and if you want to stay in, you're going to need to, beat to our drummers. And, unfortunately, the only people who can change that are the people that are actually in office.
The point.
We're in a bit of a pickle.
The good point is that, the point there is that there's no single solution for all of our problems. There's always going to be another way to address a problem, and nothing is going to be the simple way out. But at least with qualified immunity, if the Supreme Court repeals that doctrine, it will apply overnight to every government official, state, local, and federal. And so it's a really important and good step in the right direction, even though it won't get us all the way there.
Right. Well, I'm grateful for your insights. Gary, appreciate your question. I am going to go ahead and share this recording with my national audience. And I'm also, Patrick, going to make a substantial donation to you today. We're going to pretend as if you're an attorney working for, what do they call it, a white shoe law firm out of New York. We'll make sure the time that you've invested with us, was top billable hours. So it was time well spent. But anyway, listen, I very much appreciate you. This is Lloyd Princeton with Design Management Company. Thanking Patrick Giacomo with the Institute for Justice, one of my favorite organizations, who is assiduously working to protect our rights. And with that, I'm going to stop the recording, and I bid everyone a wonderful Friday and a great weekend.